we are consulting on a series of questions and proposals to design a legal framework for new funerary methods. This is part of a wider law reform project looking at the laws on burial, cremation and new funerary methods, which is divided into 3 sub-projects. In our first sub-project, we are looking at the laws relating to burial and cremation. We published our consultation paper in October 2024. This consultation paper is part of the second sub-project. The third sub-project will look at rights and obligations relating to funerary methods, funerals and remains. In England and Wales, we have laws that regulate burials, cremations and burials at sea. These laws aim to ensure that we treat the bodies of deceased people with dignity and respect. As technology advances, new funerary methods are being developed. Some of these are used in other countries. However, in England and Wales, there are no laws regulating the use of new funerary methods. This gives rise to uncertainty. Our project aims to clarify the law and set out a framework under which individual new funerary methods can be regulated in future. Acts of Parliament and secondary legislation have historically been used to regulate burials and cremation. The Cremation Act 1902, for example, provided a framework for the regulation of cremation, including the establishment of crematoria. The government used the powers in this Act of Parliament to enact detailed regulations governing cremation. Parliament could, if it wished, enact separate Acts of Parliament for each new funerary method it wanted to regulate. However, we provisionally propose that one Act of Parliament should provide a legal framework for new funerary methods more generally. As new methods are developed, the legal framework will enable the government to decide which methods should be regulated in England and Wales. Regulations made by the government could also ensure that these methods treat the bodies of deceased people with dignity and respect, as well as complying with standards designed to protect the environment and public health and safety. In our consultation paper, we make provisional proposals and ask questions about the nature and scope of this regulation-making power. We ask whether licensing could form part of the regulation of new funerary methods. We also ask whether the government should be required to have regard to certain principles before making regulations, including the preservation of human dignity. We also make provisional proposals about new criminal offences. For example, we provisionally propose that the law should state that it is unlawful to use a new funerary method that has not been regulated. While we are not proposing or advocating any particular methods, we believe a new regulatory framework will enable people to have more choice in future about what happens to our bodies after we die. To help us determine how best to regulate new funerary methods sensitively and with appropriate safeguards, we have looked at 2 funerary methods that are lawful in other countries: alkaline hydrolysis and human composting. We have also looked at the principles that underpin the regulation of existing funerary methods in England and Wales. These examples have helped us to think through the types of regulations needed to ensure the preservation of human dignity should Parliament or the government decide to regulate new funerary methods. We have launched a 3-month public consultation. Public consultation is a fundamental part of how we work. We want any recommendations we ultimately make to have as strong an evidence base as possible. We are seeking views from anyone with an interest in the regulation of new funerary methods, including the public, experts in this area, potential operators, and others involved in the death care sector. People should respond on our website www.lawcom.gov.uk by the 4th of September 2025.